Welcome to WorkCover Compass, medical facts and legal rights for injured workers in Victoria. I'm Gayan Padmasekara, and I'm an orthopaedic surgeon and shoulder specialist from Melbourne Shoulder and Upper Limb.
And I'm Sach Fernando. I'm an injury law specialist accredited by the Law Institute and also the founder of Maxiom Injury Lawyers. Between Gayan and I, we have looked after thousands of injured workers going through the worst week of their working life. And we noticed we were explaining the same things over and over again to one frightened person at a time.
So we decided to say them once, properly, for everyone. Think of us as your compass. We can't walk the path for you, but wherever you are, we can always tell you which way is north.
Today, we're starting at the start. What to do in the first 48 hours of a work injury. How to complete a claim form, and even what you might not need to do. And who all of these new people in your life will be. Let's get into it.
So section 1, things to do in that first week.
Okay, so this is a really important week. You felt some pain at work, you've come home, that pain's not going away. The first thing to do would be to get some medical attention and understand from a doctor what's actually going on. And the doctor will be able to give you what's called a certificate of capacity. And when you see the doctor, it's really important to tell the doctor about what happened at work, the type of work you actually do, the machines that you work on, a bit about the repetition of the work that you do, so that the doctor can note down a bit about what happened at work. I think where our clients fall into difficulty is down the track if they're making a claim and there's no contemporaneous note of their workplace injury. And sometimes there may be references to shoulder pain, but no reference to work. So often insurers will argue, all right, well, they're talking about shoulder pain, but they've not told the doctor anything about the work that they're doing. There's no reference to work as such. I also think it's really important that the injured worker make a complaint at work and fill in an incident report. And that can even be done before you see the doctor. If you experience some pain in your shoulder at work, let the manager know that you've been working on this machine for X period of time and you're experiencing some pain in the shoulder. Do it through a text message or do it through an email and let them know that you're about to go and get some medical attention.
Yeah, exactly. So you need to record it somewhere, because especially from where I stand, patients come to me, say, 3 or 4 months later. And when they come in, they might have the perfect example of this is a frozen shoulder. So frozen shoulder is when medical term is called adhesive capsulitis, where you have a small injury at work and it may not have been anything serious. You forget about what had actually happened. But slowly the shoulder starts to get more and more inflamed, more painful, more stiff, and it happens over weeks and months. And by the time you're in real difficulty, you probably have forgotten what the actual injury was. And without that, it's very hard to prove that it happened at work. So if something happens at work, record it, because even if you said it to your manager, people move on, memories fade, and someone may not recollect it. So, but if you've noticed put it as a text message, put it as an email, written in an incident reporting book.
That's time-stamped.
Stamped, yeah, exactly. And GP is perfect. Go see your GP and look, don't be stoic. And that's the difficulty. A lot of patients I see, the tradies and nurses, they have some pain after a shift every day anyway. So they sort of brush it off and put it aside. But if you have an injury, go to your GP, say this is what happened. So there's a record in your GP's notes. Because again, later on, if you're putting a claim in, that's what the insurer is going to ask for is your GP's records. And it'll have something that matches that injury description. So do those two things because they're really valuable.
The tradies and nurses that you just mentioned, two of the most stoic professions, I think. Yeah. And often people are very reluctant to complain.
Yeah.
They are scared that they might lose their job if they do complain, yes, or that they might be perceived as weak if they complain, especially our tradies. Yes. And often these construction industries have created this workplace culture where if you complain, you're weak. And so what we find is a lot of our clients will go for months, if not years, without complaining. Now, even if they don't complain to their supervisor, at the very least, if they've gone to their doctors and they've been talking about what's happening at work, that's also going to be really beneficial. Because whilst there's no reporting to the employer, there is in fact reporting to a medical professional ideally about the type of work that they've been doing. So from the point of view of getting the work cover claim accepted, say for example, that in that example, the tradesman goes to the doctor, makes his complaints, he's undergoing an ultrasound of the shoulder, then he gets a referral and he or she is paying out of their own pockets. And then it gets to a point where they come and see someone like yourself, Gayan, and you say, we really need to operate or we need to do a hydrodilatation and that's going to be costly. So at that point, should they wish to make a claim, then there's not going to be any issues in establishing causation, the work relationship. Ultimately, there is, even though the employer may not have known about it because the injured worker was too scared to raise any complaints, there are contemporaneous reporting of the injury to medical professionals.
Yeah.
And so you mentioned before the GP records. The GP records will be the primary evidence in any work cover claim. Insurers will want the GP records because they want to know what does the medical history look like? Have they had a shoulder problem before this? And when they get the clinical records, they're going to be seeing attendances at the doctor whilst the person is employed with the employer, complaining about their shoulder. Now, for the purposes of getting the claim accepted, you don't need to prove negligence on the part of the employer. You only need to establish that employment was causative of or was a significant contributing factor to the claimed injury, the claimed shoulder injury. And that assessment can be done by the GP. And if the injured worker has gone to the GP talking to them about the type of work that they're doing, the GP will also have a good understanding of the mechanism of injury. That might be repetitively reaching up to trolleys for 100 times in one shift. So long as the injured worker has given that history of the work that they're doing, the treating GP can conclude on the balance of probabilities. Now, those words are key because that's the standard of proof in our jurisdiction, that on the balance of probabilities, employment was a significant contributing factor to the claimed shoulder injury. And that is sufficient to get the claim accepted. Now, we know that when a claim is lodged, our clients are often sent to independent medical examiners. Again, independent medical examiners are often chosen by the insurers, and they ideally should be provided with GP notes. And for them also to review notes and see that during the course of employment, the injured worker had actually been going to doctors and talking about their shoulder pain will enable them to also conclude that employment was causative of or a significant contributing factor to the claimed shoulder injury.
Yeah. So, because at the end of the day, what the insurer wants to know is that you didn't do this at work or, playing footy on the weekend,
Exactly.
that it's related to work. So you got to create that link between your work and the claimed injury. So the other part of that is keep a record yourself of the symptoms you're going through, whether that's pain, just practical things like I couldn't get my kid into the car seat. I can't reach the top cupboard or couldn't sleep that night. Those sort of things show the impact of what you're going through. Because then months...
And a pain scale, perhaps.
Exactly, yeah.
My pain's 5 out of 10, 10 out of 10.
Exactly. Because sometimes the pain doesn't come along straight after the injury. It might take weeks or months. So keep a record of that so that when or if you do need that help, then that's there. So don't forget to report the injury.
Yep.
Go see your doctor. Make sure that's recorded within the doctor's notes, and also keep a record yourself.
Absolutely. Absolutely. And don't try and be brave. I think a lot of people think, oh, it's just a niggle in my shoulder. I'll be right. I'll take some Nurofen and Panadol and I'll be able to soldier on. And we totally understand that. Even insurers understand that. However, when it comes to crunch time in terms of getting the claim accepted, if there is no contemporaneous reporting of the incident to the employer or doctors, the claim is very likely to be denied, particularly in shoulder injuries. When it comes to women, unfortunately, insurers tend to hold this view that women are, or especially women with who are prone to diabetes or have a history of diabetes, are likely to suffer from frozen shoulder or suffer from shoulder injuries. So that's a type of nonsense that we have to deal with. Us lawyers, when we get the claim later on, they're the type of arguments that we have to overcome. And we are always able to overcome those types of arguments through the provision of supportive medical records and reports. But imagine if you're a doctor who's treating this patient with no history of what they did for work. You have to then make assumptions and conclude based on instructions you get some months later that employment could have been the cause. So good note-taking is so important. And what we do sometimes, Gayan, is we get statements from loved ones, like the spouses, the partners of our clients, because often, whilst they might not complain to the employer, might not go to doctors, they come home and they complain to their partners. So that's really important. And we find that in litigation, we either get affidavits from the partners or statutory declarations from the partners where they are able to state what those complaints were back then.
Section 2, lodging the claim and when you might not need to.
How do we lodge a work cover claim? Yeah. Now, the work cover claim form is easily accessible online. In fact, if you report your workplace injury to your employer, the employer has to keep a register of injuries. They need to record your complaint in the register of injuries, and advise you on your right to submit a work cover claim. But that often doesn't happen.
And why doesn't it happen?
Because some employers take this personally. Or it may be that they have a work cover doctor on site or a physio that they're affiliated with. They would typically encourage the workers to go and see them. And that's all well and good. That's excellent. It's an excellent resource to have. And if in fact your injury gets better, then there may be no need to lodge a work cover claim. But where it becomes problematic is if in fact, despite that treatment, you continue to get worse and there is no improvement in your shoulder condition or any condition for that matter.
Yeah, and you're right. A lot of employers now have early interventions and intervention programs. So if it's just a simple sprain or strain and you go see the physio and it gets better, that's perfect. That's the best outcome because you're back to your life, you move on. But it's when things don't go according to plan and the pain lingers, that's when you need to go through this formal process. So you tell your employer, and I hear this all the time from workers, employers don't want to lodge a claim. Why is that?
Premiums.
Okay. Yeah.
Premiums. Because every time a work cover claim is lodged, the premium gets higher and higher. Yeah. So some employers will discourage the lodgement of a claim and they might say, mate, don't lodge the claim, but we'll sort you out. We'll look after you. We'll pay all the medical expenses. There is real danger in that because if your condition gets to a point where you can't work again or it's really impacting on your capacity to do your work, at that point, the employer might say, no, we're not going to pay anymore. And also, we don't think it's work-related. And you have just delayed your rights and entitlements. For you, for the injured worker, all they need to do is report the incident, speak to the doctor, get a certificate of capacity. Now, that's different to a medical certificate. A certificate of capacity is a bit more involved. Typically, the GP will issue the first certificate of capacity where they give a diagnosis of the injury, what the restrictions are, and in the second page detail what the capacity for employment is. And that's going to be either unfit for all work, fit for suitable work, or fit for pre-injury work. That certificate, together with the claim form, should be given to your employer. And the employer has 5 business days to forward it on to their work cover insurer. And the insurer has 28 days once they receive the claim and the certificate to determine whether or not to accept the work cover claim. Now, the relevance of the certificate is that you are telling the insurer that you're making a claim not just for your medical expenses, but also your weekly payments.
So when it gets accepted, that's the 2 things that you get.
Correct, Gayan,
Yeah.
because weekly payments are only payable upon receipt of a valid certificate of capacity. And a valid certificate of capacity will have all the details in there, including the diagnosis, details of the restrictions, certification in terms of capacity. And if the certificates say incapacitated for pre-injury work or fit only for suitable employment, then the injured worker has a right to weekly payments for a total of 130 weeks. That's 2.5 years of weekly payments. That's substantial.
Yeah.
And during that time, they've got to commit to their treatment and ideally they get back on their feet. They get to a point where they can do their pre-injury work. Now, beyond 130 weeks, the test changes. In order to get payments beyond 130 weeks, the injured worker must demonstrate that they have no capacity for suitable employment indefinitely, no work capacity indefinitely, and a whole person impairment score that's 21 or more percent. That second part was only introduced 2 years ago, and what that means is it kicks a lot of people out of the WorkCover system in terms of their entitlement to weekly payments after 130 weeks.
So, and within that, one thing that I hear is it starts off, correct me if I'm wrong, 95%, and then it tapers down. So it
To 80%.
80%.
Yeah.
So it's important that workers be prepared for that because it is quite a big pay cut. Especially I've got some people who get a lot of overtime pay, and after 52 weeks, even that gets truncated down.
Well, I'm glad you raised that.
Yeah.
So let's talk about that for a moment because the legislation says shift allowances and overtimes can be calculated in the pre-injury average weekly earnings. However, after 12 months, that's then reduced to your base.
Yes.
So the 52-week mark is really important in the life of a WorkCover claim.
Yeah.
At 52 weeks, the allowances drop, and so you're down to a lower pre-injury average weekly earnings figure. And remember, from the PIAWI figure, as we call it, you get 95% and then it drops to 80%, right? So obviously, when that figure is compromised, you get paid even less.
Yes.
The other relevance of the 52-week period is at 52 weeks, the employer can terminate your employment. Now, at that stage, if the employer is satisfied that you can't return to your pre-injury employment and perform the inherent requirements of your role, they can lawfully terminate your employment, but you are entitled to have all of your leave entitlements paid out. Also at 52 weeks, you have the right to have superannuation paid. For the first 52 weeks, unfortunately, there is no super contributions, which I think is madness. But after 52 weeks, you get to nominate where the superannuation contributions should be made to. At 52 weeks, there's also a place for lawyers because typically at that time, you can lodge what's called an impairment benefits claim. That's the first of the two lump sums that I can help you with. An impairment benefit is a no-fault lump sum where you don't need to prove negligence on the part of the employer. The assessment is done based on the AMA guidelines and in the case of psychiatric injuries, the GEPIC guidelines. But you can only submit that impairment claim if your doctors confirm that your injuries are permanent and stable.
Yeah, we'll get to that again in a bit later point as well. So, but it's important to realize that you're going to get most of your payments at the beginning, but then it's going to get less and less. So you're on the clock right from the beginning.
Yeah.
So their goal is hopefully to get patients better, especially before they get to that 52-week mark. And I think that's where I really see people coming off a cliff is that the middle of the claim time where if they're not getting better, they lose their job. That's a real turning point. So I think from my side of the coin, if I can get someone back to work before that mark, they're going to be a lot more successful versus someone whose claim gets dragged on. So make sure that you get onto it early, lodge your claim. Now, say if the claim gets rejected, what are your options there?
So you must challenge that rejection.
Yeah.
Claims get rejected for a number of reasons. And the most common is that your injury is not work-related or the insurer concludes that your injury is not work-related. But why? Typically, insurers decide it's not work-related, one, because of a lack of contemporaneous medical evidence that links your injury to your employment. And this is why in the discussion we had earlier in Section 1, the importance of reporting your injury comes into the equation. If you've talked about your injury with a medical professional, or if you've written to your employer saying, "Dear manager, my shoulder is sore today after working in machine X," the insurers can't refute the fact that you've suffered a work injury. There is a contemporaneous note of your injury. But in some instances where we have people who are very stoic, we talked about tradies and nurses before, so stoic, they don't report anything to their employer. They might just think Panadol or Nurofen can heal their injury or help them manage their injury, and there's no reporting. They rely on medical evidence from doctors to establish that link on the balance of probabilities. Not likely, not possible. It has to be on the balance of probabilities. So claims are often rejected because of an absence of medical evidence that establishes the causal link. And like I said earlier, it's all about medical opinion that confirms that on the balance of probabilities, that employment was a significant contributing factor. Sometimes insurers don't get that evidence early on. And in the decision letters rejecting the claims, you'll see reference to the fact that the decision has been made because they've got to make a decision within 28 days, but they are willing to revise that decision upon the provision of supportive medical reports. But in any event, if you get a claim, if your claim is rejected, request conciliation within 60 days. Don't wait for the 60 days. Just request conciliation immediately.
Yeah.
At that point, you can call me. You can call lawyers and get some general guidance. But there is no place for legal representation at conciliations. In fact, you need special permission from the conciliation officer, from the insurer, for lawyers to be involved. It can also be costly for lawyers to get involved. There is an organisation called WorkCover Assist or Union Assist, very credible, very competent, who can help you at that stage. And if you've made contact with us and if you are a client of ours, they'll typically write to us and get our guidance anyway. And so even if we can't be fully involved in that process, we can be involved from a distance through WorkCover Assist. And typically, and let me pause here and just guide you through that conciliation process. So there's a very simple application for conciliation form that needs to be completed by the injured worker. That needs to be sent to the Workplace Injury Commission. The Workplace Injury Commission will send an email back almost immediately, attaching a document that is 1, an acknowledgement, and 2, a medical report request authority. The injured worker has to sign that and then give that authority to all of their treating doctors. Why is that important? Because you want as much evidence from all of your treating doctors to say that you've suffered a work-related injury. There's set questions in that form that the doctors and physios need to complete. The most important question there is this a work-related injury? And ideally, all of your doctors, your GP, physio, psychologist, surgeon, everyone is able to conclude that employment was a significant contributing factor to the claimed injury. Now, that material, those medical reports need to be paid for by the work cover insurer. And as a surgeon in this space, I think it's really important that you get paid for your time to write these reports before you release the report.
Yeah.
And once those reports come to conciliation, they'll be circulated to the injured worker, the legal team, WorkCover Assist, as well as the insurer. And it'll typically be a situation, if all the reports come back, multiple treating doctors saying that it's a work-related injury versus one independent medical examiner who says it's not. And that medical examiner may have formed their view without reviewing the medical records of the treating doctors or the allied health professionals. And so what it might do, the provision of the treating doctor reports might force the insurers to go and get a supplementary opinion from their independent medical examiner, putting to the independent medical examiner the clinical records and the reports obtained through the conciliation process, which will hopefully result in their decision being overturned, the adverse decision, the rejection being revoked.
Yeah.
Now, if that still can't happen, and Gayan, often it doesn't happen because the bar at conciliation is very low. What I mean by that is the insurer simply need an arguable case.
Yes.
And they have an arguable case in the event that they have an independent medical examiner, a medical professional saying it's not a work-related injury. It's a low bar, and so long as that argument is there, the conciliation officer needs to make a decision as to whether or not they will issue a genuine dispute certificate, which is a certificate that enables the injured worker to take their case to the independent review service or the magistrate's court or the arbitration. Or it may be that the conciliation officer directs that the dispute be referred to the medical panel. And the medical panel is an independent tribunal of doctors who will examine the injured worker and form their own view as to causation, as to whether employment has been a significant contributing factor. But at least through conciliation, if you've gotten those reports from your doctors, by the time it goes before a medical panel, you've got the treating doctors, GP, physio, psychologist, surgeon, that all say the injury is work-related. And then there's an independent medical examiner who's seen the injured worker once, perhaps twice at most, saying it's not a work-related injury.
Yeah.
So who will they prefer? Typically, they're going to prefer the evidence of the treating team.
Yeah. So it's important to remember that this is just a decision. It's not a verdict. So even if, as you said, if you get a rejection, it's fine. You got to just fight it. And there's systems in place to challenge that decision.
Absolutely. Absolutely. And the arbitration process was introduced only recently. And the independent review service was established probably about 5-6 years ago. And we find that even if ultimately at conciliation the matter doesn't reach resolution, say a genuine dispute certificate is awarded, decisions can be directed to arbitration or the independent review service where decisions can be revoked.
Yeah.
So, for example, at the independent review service, the decision that the independent review service members make is whether or not the insurer's decision is sustainable. And so, again, if they are met with multiple medical reports and clinical records, reports that establish the causal link and conclude that work is the causative factor or significant contributing factor, and if there are clinical records that have contemporaneous reporting of work-related shoulder problems, then they're probably going to conclude that the adverse decision, the rejection, is not sustainable.
Section 3, who's who, your cast in order. So your claim gets accepted, and then suddenly you're hearing from all these different people.
Yes.
And it's good to know a cast list because no one tells you this at the beginning.
Yeah.
But your life sort of feels like it's under a spotlight.
Yeah.
So I want to go through that and introduce some of these people, but sometimes it's important to know where they're coming from and whose interests they serve.
Yeah.
So
and what their role is.
Exactly. So the first cast member is you as an injured worker. And I'm not saying this to be cute or anything else like that, but this is your journey, this is your experience.
Yeah.
Everyone else is seeing it from the sidelines or reading about it on a piece of paper.
But you live in your own body.
Exactly. So you're the main person in this drama. So it's your journey. So you're the first person and the most important person in this whole thing.
And then there's your employer.
Yeah.
And it's important to maintain a reasonable relationship with the employer. As we discussed earlier, sometimes it can be hostile, but they do play a big role. They have obligations under the WorkCover legislation to offer you suitable work within your restrictions. In fact, there are fines that can be imposed on employers who don't offer suitable employment within the injured workers' restrictions.
Yeah. And it's interesting, a couple of years ago, WorkSafe ran a sort of qualitative study on the predictors of someone returning back to work. And the most important thing was the relationship with the employer. Yeah. So you could have a paper cut at work or, fall off a scaffolding and do something really bad. But what mattered, it wasn't the injury that played the biggest role in someone's successful return to work. It was the relationship with the employer.
It's the betrayal.
Yeah, exactly. So when people start taking it personally, and it's hard not to feel that way sometimes, but your relationship with the employer matters greatly. And, they're a very important cast member.
I think it plays a significant role in someone's recovery as well, doesn't it?
Oh, absolutely.
And we've talked about restorative justice. For example, where an employer says, I am so sorry this happened to you.
Yeah.
I wish there was something I could have done differently to stop you from being in this position. That goes such a long way.
Yeah.
But instead, you have this war that happens.
And I think it's interesting because medicine went through this 20, 30 years ago, when medical complications happen all the time. And we talk about open disclosure now. In the past where it was furlough, you couldn't tell what went wrong and then it's perceived as you're hiding something from the patient or their family. But with open disclosure now, something happens, you go say, look, this happened, I'm sorry. And saying you're sorry doesn't mean that it was bad things happen.
Yeah.
So, but
it's
that
not an admission of liability or
exactly,
guilt.
Yeah. But that really gives people the chance to heal. So, if you're an employer listening and you have an injured worker, that's a really important thing to keep in mind, because one of the common things I hear from my side is someone will come in and say, I've been in that company for 20 years and no one's called me.
Yes.
No one's, no one cares.
Yeah.
And they feel that betrayal, like you've given your whole life.
You've been loyal.
Yes, exactly.
You've given them your heart and soul and blood and sweat. And then when you're injured, they turn a blind eye.
Yeah, exactly. So employer, important cast member. The next is the WorkCover agent. Now, this is the insurance company. Now, the wording is very interesting in this context because we call them an agent, not an insurer, because they're the agent doing the work for WorkSafe Victoria. So they carry the day-to-day tasks of the legislation. So they're an administrator with a burden, essentially. And underneath them, the human person is the case manager. So, and that's a tough gig. I feel for case managers. Got a heavy caseload, usually very junior, trying to find their own feet. And so sometimes when there's delays and things, it's not malice. It's just that they have a huge caseload.
Yeah.
And there's a huge case manager turnover. It's massive. So, if you find like you've had 3 or 4 or 5 case managers and you're still within the first 3 months, that's actually not that abnormal. It's just a tough job.
So I probably wouldn't be as kind as you in your description of case managers because I have witnessed how some case managers treat my clients.
Yes.
And it's appalling.
Yes, absolutely.
And I appreciate busy a high volume of work, lots of injured workers to manage, navigating the legislation. But that is no excuse for incompetence, aggression, because at the end of the day, they are gatekeepers for this scheme.
Yes.
This is not personal.
Yes.
But often we find that they can be very argumentative, combative, and very, very disrespectful to injured workers to the point of treating them like second-class citizens. Now, I've seen the other side as well.
Yeah.
I think the older I've gotten, I've myself have become calmer in my dealings with case managers and perhaps a bit more empathetic to all those factors that you just described earlier in terms of their volume of work, the turnover often they're picking up from a previous case manager. But we're all busy.
Yes.
We all have high volumes of work, and it's really important that you treat people with respect.
Absolutely.
Especially people who've lost their livelihoods as a result of a workplace injury. They are agents of the Victorian WorkCover Authority. And at the end of the day, they need to be acting in accordance with the legislation, paying what injured workers are entitled to. And injured workers shouldn't be fighting to get what they're entitled to.
Yeah.
But unfortunately, case managers, WorkCover agents can be a barrier there. Yeah. It's their poor decision making that results in these in the litigation that we lawyers are involved in. And it's their decision-making that results in our clients' entitlements being, entitlements not being paid, or our clients needing to be part of this government bureaucracy, this whole system of fighting this David and Goliath type battle. But it is important to, when an injured worker is dealing with a case manager, to know that they are not your friend, but they're also not your enemy.
Yeah.
To be factual,
Yeah.
be firm, and be persistent.
Yeah.
For all the reasons you mentioned earlier, yes, they have lots and lots of injured workers to service, but be persistent. Send emails, keep a paper trail.
Yes.
And if you're not getting anywhere with the case manager, let your lawyer know, or let WorkSafe know, because WorkSafe have a standard for their employees, for their agents. And so if, for example, the injured worker submits a request funding for a consultation with a surgeon, they can't be taking forever to make a decision on that. They've got 10 days to make a decision on medical requests, or whether it's a surgery request. That within the first 10 days, the agents must make a decision as to whether they're going to approve it, reject it, or send the injured worker to an independent medical examiner.
Yeah, exactly. So I tell my patients this all the time. I say, if you have a good case manager, they're weight in gold.
Yeah.
So, it's, I said, be factual, be firm, but, not angry, but
Yes.
keep a calm head.
Yes.
And it's really hard
It's
when you're
so
going through
hard.
through the storm with all these pressures around you. But it's good advice to stay calm but firm in your dealings with the case manager, especially.
Yeah.
The next person is your GP.
Absolutely.
And
one of the biggest roles.
Exactly. So your most medical quarterback, they're the ones that are doing all the heavy lifting, doing the certificate capacities, your day-to-day medical care, and they're one of the most important people in your medical journey through this process.
If not the most important guy, and we lawyers place so much weight on the evidence of treating GPs. Their clinical records and their medical reports, because often our clients, the injured worker, would have been going to them for months, if not years, prior to their workplace injury. So what they have documented will ultimately determine the success of their claims. Yeah. And also keep in mind, it's the GPs that'll refer to your good self, to the surgeons, to the psychologists, to the pain specialist.
Yes.
And so having a good relationship with the GP matters. Now, also, staying with the one GP is ideal. Yeah. Now, with that said, we've had several clients that have said to us, my GP is not taking me seriously. Yeah. And I also understand how busy GPs can be. Often at these bulk billing clinics, they're seeing 40, 50, 60 patients a day. But for someone going through the workers' compensation scheme, they need a GP who will invest time in them. Understand their pain, report their pain, because ultimately it's those records that will determine the success of their claims for lump sum compensation. And so if you find that you're not making any progress with your GP, or if you feel that your GP is not taking you seriously, I do think it's important to find a GP that will. And speaking to a new GP, it's not an indicator that you're doctor shopping or you're trying to go to a doctor that'll give you that will support you for the sake of getting a financial benefit. That's of course how insurers will argue this. Yeah. The insurers might say, "Oh, well, they saw Dr. Smith and didn't like what Dr. Smith had to say and went to Dr. Joe Blow, whoever it might be." But at the end of the day, you need a GP that will support you and guide you through a very, very complex scheme.
Yeah, exactly. The next person is your physio or your OT. Now, this is the one that you have a lot of contact with. You're probably seeing them every week for your rehab, exercises, and they're going to be an integral part of your actual recovery from the injury. So they're also an important player.
And in fact, you probably spend more time with them than your GP because a consultation with a physio might go for about 45 minutes, whereas a consultation with a GP may go for 15, 20 minutes to get the certificate of capacity and perhaps some pain medication prescribed. And when it comes to allied health and especially physios, their reporting of your restriction in range of motion is really important. And it helps us lawyers determine whether or not an impairment assessor down the track has adequately assessed the whole person impairment score. Yeah. Because we can then look at the measurements taken by the impairment assessor who's been chosen by the insurer. And we can look at the treating physiotherapist's records and see whether those measurements align or whether there is a discrepancy.
Yeah, got you. And then it comes to people like me, specialists. Most WorkCover injuries hopefully can go without needing someone like my input. But when it does, my job is to help you recover. My job is not about your claim. But there is some power in that because we are trained to be objective. So I got to think about what the diagnosis is, how to treat it, and also its relationship to work. So at the end of the day, the treating specialist report does carry a lot of legal weight. Is that correct?
Oh, absolutely. Yeah. Especially on the issue of causation.
Yeah.
When it comes to proving that work was causative or was a significant contributing factor, when it comes to a physical injuries, the strength in their case will come from the treating specialist. And again, the importance of the role of a GP being to refer to a specialist, that's integral.
Yeah.
Because going to a surgeon doesn't necessarily mean you're going to be operated on.
Yeah.
It could mean that there are other avenues of treatment that should be explored first. Absolutely. And you may refer them to scans, diagnostic injections, or it may be that you refer the injured worker to a pain specialist.
Yeah.
But with your expertise, what you have to say about everything, Gayan, is going to add a lot of weight to the success of the lump sum claims.
Yeah. Then comes return to work coordinator. So they come on a little bit later in your injured worker's journey, and their job is to try to find ways to get the patient back to work, and that's within the confines of the certificate capacity.
Yes.
And it's worded as such as certificate of capacity because it's what you can do, not always what you can't do. So there will be certain restrictions. Okay, you can do some admin type work, and then it's a return to work coordinator who has to then liaise with the employer and see what options are there for someone to get back to work. And look, I am a firm believer that getting back to work, even on modified duties or even if it's 4 hours a week or something, is actually a very positive thing psychologically. If you're interacting with the same people, because, let's face it, we spend 1/3 of our life at work. So it's a huge part of social connection, belonging, purpose. So being able to get back to work in some capacity is a huge, huge deal. And it helps people heal and recover as well. So return to work coordinators can be useful in that. We see the other side of that too sometimes.
Yes.
I see your ears twitching.
So my thing is, I agree that's their role. Where this becomes a bit tricky is when they start coming into medical appointments and start influencing doctors to change certificates so that the injured worker can return to work. I think that's problematic.
Yes.
One, it's an invasion of the injured worker's privacy to be attending medical appointments. And I think doctors need to be quite firm with return to work coordinators in their willingness to accommodate those types of meetings. I don't think every return to work coordinator is the enemy.
Yeah.
I don't think they go in with bad intentions. However, they are driven also by key performance indicators. And we know that part of WorkCover's objective is to return injured workers back to work within 6 months. The reality is some workers can't.
Yes.
And that needs to be respected.
Yes.
By everyone involved, especially the return to work coordinators. And the return to work coordinator goes between doctor, the employer, and they're almost like the middleman. They'll communicate as to what the restrictions are and then find out from the employer whether those restrictions can be accommodated.
Yep.
And sometimes employers might say, look, we can't, but if they can stand up for, say, 2 hours at a stretch, there might be something that can be done. So then they end up going to the GP and saying, GP, if you can increase the restrictions, then the employer can accommodate a return to work. And that's going to be really good for the injured worker being able to get back to work, socialise with their former colleagues. It's going to be good for their mental health, and they'll somehow convince the GP to increase the restrictions.
That's what it can't be weaponized.
It can't be weaponized.
Yes.
And the difficulty, Guy, I've seen is, so say that's done and the injured worker goes back to work, then sometimes their employers don't adhere to the restrictions.
Correct. Yes.
And then our clients end up re-injuring themselves.
And re-injury is one of the worst things that can happen to someone in their recovery journey. It's the absolute worst because it breaks their trust. It's not a good thing. So I completely agree with you that in that return to work process, it needs to be safe. It cannot be weaponized. And, it has to be for the benefit of the patient. So as doctors, I think we got to stand firm on what we believe in terms of what their capacity is.
Yes.
And then whether the return to work coordinator can make that feasible or not. And sometimes it's not, because there are certain workplaces, like a construction site, you can't walk with a broken leg. There's sort of simple things that just not practicable. Then we have to accept that they can't go back to work till they recover further. But they're going to be a key player in this journey as well.
Yeah.
Moving on from that, then we got lawyers like yourself.
Yeah. And I think lawyers play an integral role in the whole process. And I always say the earlier I can get involved, the better. And personally, I'm happy to be involved from the lodgement of the claim so that we can set the claim up well, fill in the claim forms to make sure that a date of injury sometimes is not specified and that you keep it quite broad. But the primary purpose of lawyers is to pursue lump sum claims for compensation. And there's two types of lump sums. The first being an impairment benefit and the second being common law damages. And that can be significant. The statutory maximums at the moment for pain and suffering is close to $700,000 and economic loss, it's over $1.5 million. So there's substantial amounts of money to be claimed through these claims. Of course, there's a lot of criteria that need to be established. For a common law claim, that is that the injured worker has suffered a serious injury, that the consequences of the injury are more than considerable or marked, and that the injury happened as a result of the employer's negligence. But like I said, when I referenced the impairment claims, you don't always need to prove, let me rephrase that. For an impairment claim to succeed, you don't need to prove negligence. You simply need to demonstrate a level of impairment that's 10 or more % for a physical injury or 30 or more % for a psychiatric injury.
Yeah.
The other benefit in getting lawyers involved is if you are having these issues with insurers, the WorkSafe agent or the return to work coordinators, we can step in and we can make sure that your rights and entitlements are protected and that and take that burden off you. And we do as much as we can to alleviate that mental burden. But of course, there's only so much that lawyers can do.
Yeah.
But I think being aware of your legal rights and obligations will help you navigate the scheme. It'll help you manage return to work coordinators and the WorkSafe agents. And if we're also involved, we'll make sure that before you go to an independent medical examination or an impairment assessment, that you go in well prepared.
Yeah.
You know what to expect.
Actually, that's the other cast member is the independent medical examiner. So, they're independent, but that means they're independent of you as well. So they're hired by the insurance company to make an assessment, and they report back to the insurance company, not to the patient itself.
And they're paid by the insurance company.
So, so when you go into those appointments, it's important to be honest and truthful and objective, but you got to remember that it's not the same as going to see your own treating specialist or your treating doctor. It's a different environment.
Completely.
Yeah.
And you see independent medical examiners at different points. You might see an independent doctor, independent medical examiner for the determination of your claim. And that doctor's opinion will ultimately decide whether or not your claim's accepted or rejected. You might see an impairment assessor when your whole person impairment score is being assessed. You might then see an independent medical examiner again during the 52-week period or as you approach the 130-week period, and those doctors are assessing whether or not your entitlements should continue. You might also see an independent medical examiner later on down the track when your common law claim is being assessed. Doesn't matter at what stage, do your research on the doctor and understand what their role is. If you have lawyers involved, speak to your lawyers. I always tell my clients, when you go in, remember that this doctor has been chosen by the insurer or the defendant or firm that's assessing your application. Be respectful, make eye contact, because part of the process is getting the independent doctor to like you as the injured worker being assessed. Answer the question that is asked of you. Don't disclose things that you don't have to. Be direct in your responses. But if you find that you have more to say, seek permission from the independent medical examiner and ask if it's okay for you to elaborate. Because sometimes these doctors are also quite short and might be because they're busy and they're short on time. But we have some clients that say, I was there for 10 minutes, Sach. And then they've written this 6-page report saying there's nothing wrong with me. So be courteous, respectful, make eye contact, listen to the question and answer only the question that's asked of you. If there is more that you'd like to divulge, wait till the end, seek permission and disclose that. And be very detailed and descriptive in your answers. Because at the end of the day, if you can, rather than saying, oh, I've got pain in my shoulder, how does the pain impact you? Or what kind of pain? Stiffness pain? Is the pain a stiffness? Is it stabbing? When does it come about? If you can give as much detail about the pain and its impact on your day-to-day activities, I think it'll inform the independent medical examiner of the true picture. And I think it's also important when you go and see an independent doctor that you take a list of the medication, take the prescriptive medication that you take. And I think it's really important that they see you as you are, as best as possible. So let's pull the 3 bearings together, because between them, they're your whole first week.
1, create a record and don't go quiet, even if it seems minor, even if you might get it better on your own. The frozen shoulder you can't feel yet is depending on it.
If you're getting better, great. If you're not, then lodge a claim. Don't let anyone, insurers or employers, treat your hurdle as a wall.
And 3, know your cast and match your words to their role.
And because we believe in small, doable actions over big, anxious ones, here's your homework over the next week. And it's genuinely small. 3 things. Send your employer 1 written line stating what happened at work and when. Start a note on your phone as your injury diary and write a quick list of everyone currently contacting you about your injury with their role next to their name. That's it. When the cast is on paper, it stops feeling like an ambush.
One important thing before we go. Everything we've said today is general information, not personal advice. We don't know your injury or your file. Nothing here replaces your own doctor, your own specialist, or your own lawyer. If your claim's in trouble, get advice early. You can start with the WorkSafe Advisory Service or through the conciliation process through the Workplace Injury Commission.
And if today has been heavy, and we know it can be heavy, speak to your GP or someone that you trust. In Australia, you can also call Lifeline on 131114.
And if this has helped, share with someone in their injury journey. That's exactly who we made it for.
You've got your bearings now. Next time, we head into the medical journey, your treatment and that all-important certificate of capacity, and the examinations that worries people the most.
Wherever you are, we'll help you find North. This has been WorkCover Compass. Take care of yourself.